also hope to establish the coverage of the Act, establish the essential clauses and illegal terms of contract of service. We want to show the difference between the contracts, establish the legal contractual age in a contract of service, show when an employee resigns. We want to show when the employment contract is broken. We want to manage and no-show case for recruitment. We also want to understand whether sick leave, annual leave can be used to offset notice period. We also, by the end of this training, hope to know whether an employee resignation can be rejected. We want to also define misconduct, identify the differences between termination and dismissal, know the contract of service can or cannot restrict rights of employees to join, participate, or organize trade unions. We also seek to establish whether the change of employers break the continuity of a period of employment. We also seek to know the requirements for salary period and time of payment. You'll also be able to show authorized and unauthorized deductions of salaries. We also, by the end of this training, will know the requirements for salary period and time of payment, know the requirements of rest days and payment of work on rest days, establish the working hours and its limits, show the legal requirements for public holidays, sick leave and annual leave, know the restrictions on employment of children and young persons, establish the maternity leave entitlement, know what the changes to Employment Act are. We'll also be looking at legal notice number 28, the Employment Amendment Act of 2021, the Employment Amendment Act number 15 of 2022, and the proposed Employment Act Amendment Bill of 2023. So this training is supposed to take 3 hours. Again, I apologize for being 10 minutes late, but I will try to cover all the areas that I've listed and all the areas that you have in the course outline. I hope everyone has a course outline with them. If you don't, you can access it in the portal. It's available for all the people who are attending the training and those that will attend later. Wasike, kindly switch off your camera. You're distracting us. Wasike, kindly switch off the camera. Thank you very much for your cooperation. So, now, I hope you're able to see the screen. I hope you're able to see what I see on my screen. Is everyone seeing my screen?
Yes.
Yes, we can.
All right, thank you very much. Now,
Yes.
we are going to start straight away with the Employment Act, all right? The Employment Act and all specifically is the law relating to employment in Kenya. And it has several laws that work in cooperation with it, all right? It declares and defines the fundamental rights of employees. It provides basic conditions of employment of employees, regulates employment of children, and provides for matters connecting with employment. Now, you're wondering, who does this Employment Act cover? It covers everybody else except the armed forces, members of the disciplined forces, the armed forces, for example, the For example, the army, all right? Those ones are not covered under the Employment Act. They do not enjoy the rights that everybody else enjoys under the Employment Act. It does not cover the Kenya Police. It does not cover Kenya Prison Service. It does not cover the Administration Police. The National Youth Service does not fall under this category. Also, it does not cover employees of the Kenya Wildlife Service. It also does not cover employers employing only family members. You're wondering why? These particular category of people have other laws that cover their type of employment. For example, the armed forces are covered under the Armed Forces Act. Their laws are completely different from the civilians. Also, the Police Service Act covers the police, and it outlines the terms of service for them. Their terms of service are completely different from ours, because there are things that they don't enjoy as police officers, because they are members of the disciplined forces. So some level of discipline is expected of them during their period of employment, and their working conditions are quite different from what the normal citizens or expatriates get to enjoy here in Kenya. Also, there are businesses that employ only family members, and this one is common among, like, the Indians. They can choose to just employ only family members. That this Employment Act and all the rules and all the other regulations that fall under employment law in Kenya do not apply to them, because they are categorized as having special conditions of employment. I've already answered that question of why the Employment Act and the other rules do not apply to the category of persons that are listed in the slide above. Now, in Kenya, the legal contractual age is 18. That is the general rule of somebody who can sign any contract, be it a contract for sale of land, a contract for maybe a car, and in this regard, a contract of employment. The general rule is that an employer shall not engage services of any persons below the age of 18. As we always say in law, every general rule has got an exception, and the Employment Rules and Act does not depart from this exception. The exceptions that we'll be discussing shortly in this session that are exceptions to this general rule of employment of persons above the age of 18. Exception is that one can employ a person who is 18 years subject to set conditions. We'll discuss that in the next slides. Also, in very few circumstances, we have an exception where an employer can employ persons who are 13 years and above, like between the age of 13 and 16. They can also be employed by an employer. We will discuss the conditions set by the Employment Act and the rules in the next slide. Now, we will jump directly, because we are going to tackle all the other terms of service and continue to understand the employment law, but I want to tackle first this aspect of people who are under the age of 18, because it is important for us to understand this before we go on to the rest. I'm not saying you should go now and start employing people who are below the age of 18. There are specific rules that have been set out by the Employment Act and the regulations pertaining this. If an employer is to employ somebody below the age of 18, that employer is supposed to get written permission of an authorized officer You cannot just get children from everywhere and you start employing them. Remember, anybody below the age of 18 is considered a child in Kenya, and they do not have they have not attained the legal age of contracting employment, signing any other kind of contract. So if you want to employ a 16-year-old, 17-year-old, 17 and a half, you have to follow the following rules. You have to get a written permission of an authorized officer, all right? And if that child is to be employed, you're not to employ the child in circumstances that he or she will be away from a parent or a guardian unless written permission has been granted. This is a very tricky one. Because if you think of it, if somebody is below 18, why are they seeking employment, even with the permission of their parents? That brings us to another aspect of the law whereby the law limits exploitation of children and child labor. There's a very thin line between getting permission from a guardian and subjecting a child to child labor. You are not to employ a child in a bar, a hotel, a restaurant, club, liquor store, or as a tourist guide. Sometimes you go to villages and you find there are these children who are trying to make a living and they are taking tourists around, showing them the area. Now, if you employ such kind of child in such environment, it is not recommended under the law, and you could actually face serious consequences if you do this. If you employ a child in a bar, restaurant, or hotel, this is because those kinds of environments, they could corrupt the development of the child. They could corrupt the morals of the child. And I think specifically, this rule was put for purposes of protecting children who are in areas where tourism is thriving. For example, in the coast, you find many children don't go to school and they decide to be, they call it beach boys, right? They say, oh, I'll just go to the beach and take a mzungu around and then I'll be paid for it. So if you are somebody who is operating a tours and travel agency and you find that children are easier to pay or easier to employ, know that the law prohibits this specifically. It prohibits this specifically because they know the danger. Because you find in the coastal area, many children opt not to go to school. I happen to live here and I see you go to the villages or you're walking around the beach during school time, and there are people who you evidently see are not 18 years. They do not go to school. Even when you try to force them to go to school, they refuse. Their parents say, oh, I'm struggling with this and this. Some parents have no option but to engage the law, to engage the police service or something to put sense in the children, to speak to them and guide them into, because the people who formed the law knew that these people will choose not to go to school and opt to go to the beach and take these people around. A child not to work if it is, I beg your pardon, a child should not be engaged in work if it denies him or her opportunity to go to school. That again goes back to the point that we were discussing up there. Because the children, when they test the money, they do not want to go to school anymore. I was being told of Mwea, where rice is grown, right? Many people, the rice farmers, find it cheaper to pay the children to chase away the birds, especially when it's close to harvesting time. They engage the services of children to chase away the birds because it's cheap for them. And the children have energy. They can run after the birds and chase them and all that. But once these children test the money, they refuse to go to school. They refuse to go to school. Even now, engaging them during holiday season, because somebody can say, oh, I will engage them only during the holiday season and it will not be much of a problem. Okay? Once these children test the money, they do not go back to school. And that's a real problem because now What happens when it's not the season for rice? What happens when it's dry season and there's no rice? Where do these children go? It becomes a real problem. Children not to work if it substantially restricts the child's opportunity to play with other children. For example, when these children go to work in the rice farm, or they go to take the people to the beach or everywhere, they are not playing with their fellow children. I'm talking about people who are below the age of 18. Maybe some people may say, oh, those are teenagers, they don't even want to play. It is important for the children to play. All right, I'll not go into the details of that, but the law makers know that it is important for the children to play, because we have scenarios these days where people did not play when they were children, and then when they become adults in their 2025s, they start engaging in things that they could have engaged in when they were 15 years old. And people start saying, oh, midlife crisis, is because they were denied the opportunity to play. Children not to perform the following as prescribed in section 4, considered to be harmful to the health, safety, and morals of the children. Because children are the future anyway. If their morals are corrupted, who is going to lead the country moving forward? If their health is deteriorating because of the work, who is going to take care of the country when we are out of here? When we are older, when we are in our 70s, if the children are not there? These are the future. That is why the law seeks to protect them. They will not engage in housekeeping, food preparation, laundry, border transport, because many children don't want to go to school. So people just give them border and say, you bring me 100 shillings or 1,000 shillings every day. It exposes them to a lot of harm, to imminent danger, especially road accidents and all that. They should not serve as porters in building sites. This we see a lot. They should not push handcarts. They should not engage in gang wars, bullfighting, ferrying of ammunition, underground digging and extraction of minerals, carrying heavy loads, refining minerals, gathering sand from the riverbed, depressions and pits, lifting heavy loads, climbing mira trees to harvest twigs. Yes, this is very important, especially in areas of where mira is grown, because I'm told, I've never seen, the tree grows facing downwards, I think. So they find that the children are lighter, they have lighter weight, so they can go up the tree and pick the twigs, and then they will not break the tree. This is very dangerous. They should not be engaged in looking after cattle for more than 2 hours in a day. Okay, this one sought to protect the cattle rearing communities. At least they can go to herd the cattle for 2 hours max. Brick making process involving extraction, crushing, grinding, screaming, and mixing works. All right, working with machineries, working with chemicals, moving heavy loads of animal feeds, ferrying heavy farm produce, any work in industrial and undertaking or warehousing, earth digging, carrying heavy loads in construction works, breaking stones, rocks, shoving sand, ballast, cement, or soil, metal works, welding, ascending to high places, working with ladders, work in confined spaces, working with risk of structural collapse, diving to depths of up to 60 meters to perform any work, working with molten glass, carrying molten looms, mixing hot steam chemicals, making matchsticks, sniffing crater powder, tanning and presuming hides and skins, begging. This is very specific, begging, use of toddlers to ask for alms. This also happens a lot in the cities, where mothers sit in a shed and then they put their children or babies outside, and then they are begging for alms. It's very, 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 it's not allowed in the law. And if you're caught doing this, if anybody is caught doing this, they will be subjected to serious legal consequences. All right. Reclaiming I beg your pardon, reclaiming usable materials from garbage. This also happens a lot in the urban areas. Glue sniffing, I don't know whether that is work. Glue sniffing is not work. I don't know why they consider this. Tour guide, entertainment, performance, hospitality, service, commercial modeling, and commercial hairdressing. In the areas of the coast, you find these people who are always on the coastline, all right? They are on the beach and they are performing these aerobics. And you find the people, they get the little children and they're the ones who they put up because of their weight. They put them like on top of the tower when they're making the pyramids or the towers or whatever they are doing. And the little children are up there. You wonder, are these children not supposed to be in school? And isn't it harmful to them? What if the child falls? Anyway, so that is what they sought to protect. Children between the age of 13 and 16 can be employed to do the following. Now, this was done in consideration of the fact that some people need to engage in training. For example, with the new system of school, you find we are going more practical than theoretical. So this one was brought about, I think, to cover that area of that gap. In case somebody is 14 and then they need to practice some things from school, you know, to help them in the future. What if? As they can do the following, they can be an apprentice or they can work as an apprentice or indentured learner in accordance with Industrial Training Act, or in accordance to Schedule 5 of the rules. Work performed at a school as part of a school curriculum for the benefit of the child. For example, you see in some schools, they engage the children in baking, and then after the baking, they allow the children to sell the cakes or the cookies or everything that they baked, all right, to the community or to their parents or something, so that they can encourage the aspect of trade in the children. They can also engage in agriculture or horticulture, not exceeding 2 hours per day. That is only for children between the age of 13 and 16, not below. Deliver non-bulky newspapers or printed material. Excuse me. They can work in a shop, including shelf stacking, you know, like especially if it's a family business. They can do domestic hairdressing, not commercial hairdressing. They can also do light office work. They can wash the car by hand in a private residential setting. Okay, this is interesting. They can work in a cafe or restaurant strictly to wait tables. Strictly to wait tables. Okay, those children, if you seek to employ the people who are below 18, you must get a permit to employ children, and it must be renewed every year if you must employ those children. A person in charge of children's welfare to be approved by a labor commissioner if one employs more than 10 children on a permanent basis. Medical certificate to be provided before employing a child on a ship which employs members of more than 2 families. And this certificate is valid for only 1 year. Punishments for contravening the rules pertaining to children employment is a fine of 100,000 or 6 months in prison or both. So if you do not follow the rules, if you just employ children the way you like, and you're not following the rules that we've discussed above, you can go to prison. You can pay a fine of 100,000 or both. Remember, the law can decide to give you both. Now, we are going into the area of recruitment before we move on to the area of contracts, because I know maybe you're wondering, why are we not going straight into contracts? We want to be able to establish first who can sign a contract of employment, a contract of service, who can sign this contract. So before we move to that, we are going into the area of recruitment, and we want to discuss management of no-show. All right, like if you advertise a position as an employer or an HR manager, and people do not show up for these opportunities, for the interview, maybe they applied for the job and they did not show up for the interview. How do you go about this before we go into the signing of the agreements and all that, and before we go to discuss the other terms of employment? So if you do an advertisement and people do not show up, or somebody who applied for the role does not show up, you need to make sure, number one, you have documented all communication. All right, ensure that all communication with the candidate regarding the interview schedule is documented, whether it's through email, phone call, or any other means. These days, they even advertise positions on WhatsApp. So if you advertised and asked people to send their email, to send you an email of their CV and their documents, do all these further communications through documentation, because sometimes people actually go to court and say, oh, you know, this position was advertised, I applied for the position, and they never got back to me, or they sent me an email even after the interview was done. So in case somebody does not report or does not show up for the interview, you now have a fallback position. If you wrote to them, you're able to now communicate, you're able to follow up. That brings us to the second step. You follow up in case of a no-show. If you did not communicate in the first place, you cannot follow up on the failed recruitment, on the failed show. Now, how do you follow up? If a candidate does not show up for an interview, reach out to them promptly to inquire about the reason why they did not come. Sometimes there's really a genuine reason for them not showing up. You know, it's not that, oh, I applied for the job and I don't feel like it. No, maybe there's a genuine reason why the person did not follow up. Now, I mean, did not show up. If they do not show up and you follow up with them, if they are still interested, you can consider rescheduling. You know, you can reschedule the interview so that you get the best candidate. Because remember, as an HR manager, you are working in the best interest of the organization. After you have done a follow-up and you have rescheduled, if possible, if you've rescheduled, if possible, you can now go and review your recruitment process. Like, find out as an HR manager, why did these people not show up? If the candidates did not show up, review your recruitment process to identify any potential shortcomings or areas for improvement that may have contributed to the candidate not showing up. You know, maybe the communication was not timely. If that is the case, you can try to communicate earlier. You have to make sure that your communication is very clear. It's important not to just think that this person did not show up, they are not interested. No, maybe the way you communicated was not clear and was not specific. All right. Now, this is very important. The next point, maintain professionalism. Even if somebody did not show up, maintain professionalism when you are getting back to them. When you're trying to follow up, be professional. Do not say, oh, this person did not show up, so who cares about them? No. Remember, they could still be the best candidate for your organization. You know, they could be the best candidate. So when you're talking to them, when you're following up with them, or when you are rescheduling the interview, try to be professional, maintain the professionalism, because at the end of the day, you may find out that this was the best candidate and they actually join the organization and do a good job. All right. You can consider alternatives. If the people do not show up, you follow up with them and they're still not interested, you can interview somebody else for the position. Finally, you can track the patterns. If you notice a pattern of people not showing up for interviews, consider implementing measures such as confirmation emails or reminders to reduce the likelihood of future occurrences. For example, if you notice you've put up an interview, you've put up a recruitment post, and then people apply for the job and then they don't show up, then the next time, you should reconsider. Look at the pattern, understand it, and ask yourself, why are people not showing up? Are you communicating late? You know, are you communicating late? Are you not being specific on the time? As an HR manager, it is important so that you get the best candidate for the organization that you are seeking that you're working for. Now, this moves us to the next segment. I know this is where now everybody is going to open their ears. Because you're wondering, why are we going through all this? It is important for you to understand the contractual age and the process. I know you understand the process of recruitment, but how to handle the no-show is very important for you as an HR manager as well. So now we are delving into the real law now, okay? First of all, we have two types of contracts. Two types of contracts. We have the contract for service and contract of service. This is very important. Contract for service is required when one wants to engage the services of a third party as an independent contractor for a specific project or a short-lived purpose. For example, they are all these people who are doing tenders. Somebody applies for a tender, they are given a tender. They do the service, maybe they make the road or supply materials. They cannot claim to be employed by the government. They cannot claim to be employed by the county governments or the organization that you work for. Maybe you tell them, oh, just bring us a lorry of sand every day for 6 months. You know, they cannot be considered to be working for or to be an employee of the organization. On the other hand, a contract of service is a contract used in labor law to attribute rights and obligations between the parties to the bargain. So what we are interested in today is the contract of service. This is what is governed by the employment laws. All the labor laws govern this contract of service. That is the one that establishes the employer-employee relationship. Without this, there is no rights, there is no obligations. All right, okay. The other one also has rights and obligations, which include the right to be paid, and then you have to perform the contract. That's why you see many people are being sued by the governments or the counties because they did not deliver. So when it comes to a contract of service, which is the employment contract. Now, I'm going to stop saying contract of service and contract for service because sometimes it confuses the people. The employment contract, right? Employment contract is the contract of service. We have different types of contracts of service, the employment contracts. We have permanent contracts. Many times people want this title. They call it P&P, right? P&P. Oh, I want a P&P contract. If you're wondering what P&P is permanent and pensionable contract. Now, these ones are common in the government. These days, even the county government does not give P&P. Most of them, they give you for 5 years. And then when the government changes, we have so many court cases. Oh, the new governor dismissed me. So these days, they have really changed their system. But we have a permanent contract, permanent and pensionable. People like those ones. There are contracts for a fixed term, whereby you say, I will give you a contract for 1 year. Once it is done, we are done. Then there are casual contracts. You come to my place every day for 2 months, you know, every day I'll pay you on a daily. there's that kind of contract as well. I've already explained this, but I will go deeper. Permanent employment contracts apply to employees who work regular hours and are paid a salary or hourly rate. The contracts are ongoing and are terminated by either employer or employee and may be for a full or a part-time work. These are very common in the...
Sorry, I have a question before you continue, madam.
Okay, if we start asking the questions now, we may not finish. Maybe you can write it down in the chat. Then I will be answering. We'll have a Q&A question. I mean, a Q&A segment.
Okay.
Is that okay? Yes,
okay.
I will have a Q&A segment after the presentation. Thank you so much. We have the fixed term contracts where it is set to end at a specific day, maybe for 6 months or 1 year, it ends like that. The moment the year ends, it's over. Some people don't like their contract being over because when the year ends now, they start, and you did not renew the contract, they just start coming to work. They don't want the contract to be over. Now, if you make the mistake and you pay them, it is now implied that the contract has continued. Casual contract, these are contracts specified, I beg your pardon, the casual contract specifies the minimum number of hours that you are expected to work each week, with the exceptions, I beg your pardon, with the expectations being that the working pattern and hours offered above this minimum is likely to fluctuate. This is common in the industrial sector. Like you find maybe an industry making plastics and they need, maybe this period they need 100 workers, then the next period they need 20 workers. So they could take on people for like a week and then they tell them next week don't come. Many people complain after they are used to the daily pay. When now they tell them, hey, today there is no work, they complain, they go to court. They go to court. Now, when does a casual contract change into an employment contract? When does a casual contract, Jasper, please, your camera is distracting us a bit. When does a casual contract change to employment contract? If not an employee, at this point they are not an employee. If a casual worker works for a period or a number of continuous working days, which amounts in aggregate to the equivalent of not less than 1 month. I don't know if you understand that one. If you have somebody working for you every day for 1 month, continuously, that type of engagement will now automatically convert to employment. It will automatically convert. If the person performs work which cannot reasonably be expected to be completed within a period or a number of working days amounting in an aggregate of, I beg your pardon, amounting in aggregate to an equivalent of 3 months. You may find yourself becoming an employer just like that. This also happens in the industrial sector, whereby people work and then after 3 months, when you want to stop them, they tell you, no, you cannot stop me. I'm now your employee. You need to pay me all these things that we'll be discussing in the next slides. So, if you find yourself converting or being converted to an employer without your knowledge, you need to take action. But before that happens, make sure if you're doing a casual contract, it is specific. It is specific, and give the people a break. All right? If they are working for a month, after the 1 month, give them a break, even for a week. Then call them back. Otherwise, they will now turn into your employees, and then you will be considered as an employer. We will delve slightly into the legal aspects regarding prohibition of forced labor. Because many a times when people are forced into labor without knowing, sometimes. So the Employment Act prohibits forced labor in terms of recruitment and trafficking of forced labor. Sometimes you see people being brought in. Okay, I don't know whether it still happens, but those years you find people saying, "Oh, we are bringing people from maybe Congo or from Uganda or somewhere to come do some work by force." By force, they don't even know they are being forced. They are just told, "Oh, just come to Kenya," and then they are kept in a house. Okay, I'm not saying it happens. It happens in those other places. I don't think it happens in Kenya. They are being kept in a house and then they go out only at night to perform some duties, and then in the morning they're in the house. They don't even know where they live. They don't know anybody. So the Employment Act prohibits this. Recruitment and trafficking of forced labor. It outlaws discrimination in employment and provides for equality for employment opportunities. It provides opportunities for legal migrants and their dependents. It emphasizes that discrimination should be eliminated in both policies and practice. Sometimes you hear these kind of adverts, these kinds of advertisement. We are looking for these people, and they must be male or they must be female. That one is a question mark, and the Employment Act does not like it. But there are exceptions. As we said, every general rule has exceptions. The law, however, provides for the following, that the following shall not amount to discrimination: affirmative action. For example, okay, this is not employment, but the 1/3 gender rule. That one is affirmative action, where they say if you must have a board, 1/3 of it must be female. You must have females on the board. And that is because those people were initially discriminated. Persons living with disability, initially they were discriminated against by employers. So the law now can say, an employer now can say, this job will want persons living with disabilities, or this job will want women, you know. So if it's affirmative action, then you are allowed to discriminate. They call it positive discrimination. Positive discrimination, all right? Then there are some jobs that inherently prefer a specific type of people. I will not go into the details of that, but there may be a preference on inherent requirements for a job. Employment of citizens in line with prevailing policy. For example, in Kenya, if you want mostly these government jobs, requirement number 1, you must be a Kenyan citizen. This one is there to protect the integrity and employment for citizens. You know, I don't think I've ever seen in Kenya a non-citizen judicial officer. If you've seen one, please write in the chat and tell me. Like, personally, I am they call it expatriate, right? I'm an expatriate in Kenya. I can never apply for magistrate's job. I have the experience of almost 10 years, but I can't apply for it because they want citizens. Even when you apply, they will just call for you for the interview. Nothing. I've not seen jobs like judicial officers, because to whom do you pay your allegiance? You know, that's very important. Judicial officers, anybody working in the judiciary, I've never seen a foreigner being employed. Yes, you will go for the interview. You will apply for the job. You'll go for the interview. They'll even call you for the second interview. And then, hey, when the list comes out, 0. I've never seen. All right. So they are protecting the citizens because this work is for the citizens. This work is for the citizens. Anyway, let me not delve so much into that. There are also policies that restrict access to employment due to security reasons, state security. For example, jobs like judicial officers, people who work in the parliament, except for those, where they put it, oh, this person is from, I don't know where. Mostly, you find that this is due to state security. They don't want their secrets to be going to other countries. They don't want their secrets to be going to other countries. For example, if you have, let's say, the Supreme Court justice, the justices of the Supreme Court, and then they are not from Kenya, who are they protecting? When an election petition comes, how is it going to work? So there are those jobs where they will discriminate. In fact, they will just say, must be a Kenyan citizen, and there's nothing you can do about it. There's nothing you can do about it, which is very important because the security of the country is very, very, very important, especially for the citizens. There are laws that provide that where allegations of discriminations are made, the burden of proof rests upon the employer. The burden of proof rests upon the employer. For example, there's this case I was looking at. Let me just check it. I had written it here in my notes. Yeah. There is a case of James Mwathi Nguri versus Egerton University, whereby they were forcing this person to go on retirement when it was not their time. It was upon the university to prove that they did not discriminate against him. It was upon the university. So as an employer, you will be put to task. If I come and complain, oh, this one is only, it happens a lot in our legal field, whereby you see an advert and it says, we want a male lawyer. We want a male advocate. Because they say the women, they will go and get pregnant and then they will want maternity leave. So they are not giving them the jobs, Or the women will call to say their children are sick and they are taking them to hospital. So they say, we want a male advocate. So if somebody complains and says you are being discriminatory, it's upon you as an employer to prove that you have not discriminated. It's a very tricky situation. We are moving on from discrimination. We are now going to sexual harassment. The employment law protects employees from sexual harassment. All right? The Employment Act has defined sexual harassment, and it refers to any activity, all right? How do I put it? Any insinuation in the following aspects. Request for sexual favors in return for preferential treatment. This used to happen a lot. That is why the makers of the law had to move into action, because people were suffering in employment. They cannot get a promotion because they did not give sexual favor to the boss. It was very wrong. So they had to come in and put this law into play. Treatment for, I beg your pardon, there are some people who threaten their employees. They say, if you don't give me sexual favor, I will not pay you a salary, I will not give you the promotion. So they give the threats for these sexual favors. The law has outlawed all these things, right? Threats for a current or future employment. There are some people where those days, I'm told, thank God I was not there. I was told for a woman to get a job or to be promised a job, they would have to give sexual favors. That was very, very wrong. Very, very wrong. And at least the law came to cure it. Though it still happens. I know it still happens. though people are quiet about it, because how will you prove it? Proving it is also very difficult, you know. But yeah, if you have the evidence, by all means, go to court. Tell the court this person asked for this, and they refused to give me a promotion because of this. Now, if you use any language, spoken or written, that is sexual in nature, it is considered to be sexual harassment. I don't want to go so much in details of that. Use of visual material or sexual nature. Use of physical behavior or sexual nature or unwelcome behavior. The law provides that where there are 20 or more employees, the employer, with consultation with employees or employee representatives, should develop a sexual harassment policy. How many of you have a sexual harassment policy in your organization? If you have, if you have more than 20 workers, you need that, because otherwise, you will have problems if you don't have these policies. If you are now faced with a case of sexual harassment, how are you going to deal with it without the policies in place? So make sure if you have more than 20 people in your employment, you should have a sexual harassment policy. Sexual harassment policy means a policy against sexual harassment. Don't think that I'm saying that you should have sexual harassment. No, you should have a policy against sexual harassment and how you're going to deal with those problems when they come. Okay. Now, all contracts of employment must be created under the provisions of the Employment Act. No contract of employment can be entered except under the Employment Act. A contract of employment can be entered into orally. Some people just call you, come start working here. It can be implied or in writing. For example, somebody just comes every day to your compound. Mudani, Falkins Mudani, please switch off your camera. Thank you, thank you. Somebody just comes to your compound and then they slash the grass, you pay them 100 shillings. They come again tomorrow, they move the house, you pay him 100 shillings. If they do that for a month and you keep paying them and you're not telling them to leave, it will be implied that you're their employer, whether it is in writing or not. However, contracts for a period, Mdani, your camera is still on. It's distracting. I'm sorry to tell you to switch it off. Thank you, thank you. However, contracts for a period of number of days aggregating to 3 months or a specific or a specific work which cannot be reasonably completed within a period amounting to aggregate number of days amounting to 3 months must be in writing. So this one was put there to protect the employers or the employees from this, what we were discussing before about casual laborers who are now converted into employees. If it is not in writing, there will be a problem because the worker will not be able to prove that they've been working for you. The worker will not be able to prove, you know. So they now decided to protect the worker and said, if you're doing this for something that is more than 3 months, it will take more than 3 months, but it is a casual contract. Make sure you put it in writing. Make sure you put it in writing. Oh no, sorry. This slide interchanged. I'm sorry for that. I'm sorry for that. Now that I've already moved onto the contract, we'll have to discuss this maybe in the AOB. We can go back to it because it will now disturb the flow. So It is the obligation. It is the obligation of the employer to put the contract in writing. It is not for the employee because, I mean, how will they write their own terms? It is the obligation of the employer to put the contract in writing. Now, the contract must state the particulars of employment and must be consented by the employee. That is by signature. When the terms have been set out, the employee must sign to show that they indeed have accepted the terms of employment. Excuse me. So the employee must sign his name or their signature, or they can put a thumbprint. The thumbprint must be put in the presence of a person different from the employer. If they put the thumbprint. Where the employee is illiterate or where the employee cannot understand the language in which the contract is written, then the employer is required to explain the contract to the employee in a language that he can understand. Many times people go to the industrial sector and then they're working there and they do not understand the English, or maybe you're given a booklet of contract, it is very big, you don't understand it. Since you want the money, you just sign. Or since the employee wants the money, because you, the HR manager, you understand. So this person, they just want employment, they just want money. So they just sign without even reading, without even understanding whatever they are signing. It is the employer's obligation to explain this employment contract to the employee. All written contracts of employment must state the following. Number one, the name of the employee, the age of the employee. I've not seen a contract that states the age of the employee. I've not seen it. I wonder why. I wonder why. Now, this one will help the employer when it comes to retirement. It will help the employer when it comes to retirement. It should include the permanent address. The permanent address will assist you when you are firing this person. When you are terminating this person, where do you serve the letter? Maybe this person has absconded from work, then you want to terminate because of absconding. Or they've not come, they've come to the work drunk or something. Those things we'll be discussing in the next slides. Where will you serve? Make sure they give you their permanent address, so that when you want to serve court documents, when you want to serve any letters, you can take them to that address, and then they cannot say, oh, I did not receive it, because after all, they're the ones who gave you that address. Those days, it was PO box. These days, nobody has post box. Who has a post box? People are using WhatsApp and email and whatever. So I think this one also should be changed. They should now put permanent email, because the box does not work anymore. Nobody wants to pay for the poster when they have WhatsApp. It must include the sex of the employee, either male or female. This one will help you when it comes to maternity leave. In the contract, specify that this employee is male or female, because if you don't specify, these days, things are changing. People are now changing their sex when it is convenient. So somebody may do a number on you and change. And then they ask you for maternity leave. And they're like, no, but when I employed you, you were a male. So it is important. It is important to put the sex of the employee. It also should have the name of the employer. Be specific. Who is employing this person? In case the person wants to sue for their salary. Because maybe these days we have many recruitment agencies. The recruitment agency will recruit somebody and then they will be employed somewhere. Now, when the person wants to sue, they go to the agents. They are complaining. They did mistakes in their job. The person fired them. Now they are going to sue the employment agency. It's important to say who the employer is. Also, it's important to say the job description, because some people will come and say, oh, I was employed as a cleaner, but now I was doing the duties of a receptionist. Now I want to be paid for both cleaner and receptionist. You must say, this person is employed as a receptionist to do this, this, and this, and this. So that when you now give them the job of the cleaner, they can ask you for more pay. Or when they are suing you, they say, I am supposed to be paid double salary because I was doubling as the receptionist and the cleaner. You can now say, no, your job description was this and this and this. It also should include the date of commencement. This one is important for calculation of service. I mean, of what is it called? It is important for calculation during termination or retirement for the benefits. For the benefits of the client, I mean of the employee. It should also include the form and duration of contract. Is it permanent? Is it permanent and pensionable? Kira, your camera is distracting us. If you could switch it off. Thank you. It should include whether it is a permanent one, a permanent employment, or whether it's a term contract, maybe 2 years or 3 years. It should include that, so that when it is over, it is over. If you do not include that, somebody will say, oh, me, I was employed permanently. You did not specify. It should also include the place of work, the hours of work, the remuneration. How much are you paying this person? For example, the government has scales. Class K, is it scale K, scale J, scale G? It should also put, for government employees, it should have the scale. It should have the method of calculation. For example, maybe you're paying them on an hourly basis. I'm told in some places people are paid by the hour. The hours you work is what you earn. All right. And then it should also include benefits. What do they get apart from their salary, apart from their remuneration? Is there anything else that you will be giving them as an employer? Is there anything else you'll be giving them as an employer apart from their salary? You should also discuss that. Now, when we are talking about salaries, at this point now, we need to understand how salaries are paid. The salary can be paid in cash, in check, bank transfer, or to an authorized person. Now, where does M-Pesa fall? M-Pesa falls in bank transfer, right? Because it's a transfer. M-Pesa falls in bank transfer. What do we mean when we say authorized person? Somebody may come and say, oh, you did not pay me my month's salary. And then you say, oh, I gave it to your wife. In the contract, did they sign that their salary must go to their wife? If they did not, you'll pay them twice. But in this case, an authorized person could be, maybe they're supposed to do a maintenance for somebody. Maybe they have a child somewhere and they are not taking care of the child. So the court gives an order that that person's salary be attached. You should be paying 2,000 to the caregiver of the child every month. So the caregiver of the child becomes an authorized person. It could be that the person is satisfying a debt. You know, you say, oh, instead of paying me, you can pay my landlord rent every month, 5,000, and then they sign. That becomes an authorized person. If maybe there's a court order saying you have a debt of 5 million and your salary will be attached, they say a third of your salary will be attached until you satisfy the debt. The the creditor becomes, the decree holder becomes the authorized person. So it's important to note that. Place and time of payments of salary, you must pay on a working day. Pay the people on a working day. Don't pay them on Sunday. You just met in church and then you are giving them the money. Pay them on a working day. Pay them during working hours. You are not supposed to pay somebody when they are in a place of intoxication, excuse me, or where the liquor is being sold. Some bosses have bad manners. They call their employees to the club and then they pay them their salary and then they tell them, buy me drinks. It's wrong. If this person comes and says you did not pay them, it's now your problem. You have to prove that you actually paid them. In case of payments in kind, it must be agreed. Maybe some people say, oh, don't give me my salary at the end of the month. Just bring me a bag of unga, ya chapati. Faith, kindly switch off your camera. Thank you, Faith. Oh, just give me a bag of unga ya chapati and I will be good. You must agree. You cannot say, oh, I sent you a chicken. When is salary paid? Salary for casuals is paid on a daily basis or as agreed by parties. There are people who are paid on commission. They can be paid daily or as agreed. Maybe they say, I pay once every week. That is also fine. People who are working for less than a month period at the end of the stipulated period. Maybe you're giving work to somebody for 3 weeks. When the 3 weeks end, you now pay them their salary. At the end of every month in other cases. For example, if somebody has normal employment, they'll be paid at the end of every month. In case of dismissal or upon dismissal, you must pay the salary of this person. No payments of salary should be done where the employee is serving a sentence of the court or is in prison. For example, this person worked for you and unfortunately they got a court case, all right? And then they were sent to prison. You can't pay them when they're in prison. You now have to keep their salary until the day they come out of prison. You know? That's what the law says. That's what the law says. What happens to people who are serving probation? I wonder what happens to people serving probation. Anyway, moving forward, how do you pay salary and what will inform what they call it, the salary slip or the pay slip? What should be on your pay slip? What should be on your pay slip as an HR manager? Number one, you have to give this person an itemized statement. You cannot just give somebody 50,000. You just pay them and say, that's your salary. No. You must have an itemized statement which should state the basic pay, statutory deductions, overtime pay, if any, payment in lieu of leave, if any, and any other deductions, which we are going to be discussing in the next slides. Now, deductions can include pay as you earn. Pay as you earn. Pay as you earn is a tax collection method by the government. It's a method used to collect tax from residents and non-resident individuals from profitable employment. This is one of the deductions. This is one of the deductions that must be done. If somebody earns a salary of 24,000 and above, they must pay payee. What do they mean by profitable employment? Profitable employment includes wages, salary, leave pay, sick pay, fees, commissions, bonus, gratuity, traveling allowance, and other allowances that employees receive from rendering services. That brings us to the aspect where some people say, oh, this is my allowance. It is not supposed to be taxed. No. KRA will tax that allowance. If you're giving, is it sitting allowance? There are some people who just get sitting allowance. I don't know what that is for, but yeah, they get sitting allowance. Even this thing called per diem. I think that is why they pay it in M-Pesa these days, so that it is not taxed. Anyway, I hope KRA is not here. They pay it in M-Pesa, so it is not put on the salary slip, but all this is supposed to be taxed. So if you earn more than or an income of 24,000, you must remit payee before each ninth day of the month. For example, if you pay your workers on 30th of January or 31st of January, by 9th of February, you must remit their payee. If you don't remit their payee, KRA will come for you. They will come for you. Now, there are some benefits that are taxable. There are benefits that are taxable. Vehicle or car benefit is taxable. If the company is giving you a vehicle, KRA will now come and assess, and then they will tax that car benefit. Provision of housing is also taxable. Loans at interest rates lower than the market rates. For example, if you are an employer and you give a loan to your employee for an interest rate of 2% per annum, the government wants its money. They will come and tax it. Housing facilities such as water, electricity, telephone, security, and other expenses over 3,000 a month. I think this needs to be changed because 3,000 is not much these days. Now, if you're taxing 3,000, even KPLC, if you're using electricity less than 3,000 in a month in this Kenya now, you're very lucky. This needs to be changed. 3,000 is too low a figure in this day and age for it to be taxed. They need to put it, I think, to like 10,000. If you're in the law-making institution, please tell them to change this, as they are planning to change another area. There is a bill in Parliament that we'll be discussing in the next slides. They should change this 3,000 thing. It's too little. Pension contribution paid by a tax-exempt employer to an unregistered plan of over 20,000 is also taxable. Medical cover by, I beg your pardon, these benefits are not chargeable under payee. You cannot charge payee for medical cover by an employer. Pension contributions paid by a tax-exempt employer to an unregistered plan below 20,000. Pension contribution paid by the employer to a registered plan below 20,000 per month is also not taxable. Amount paid by the employer to reimbursement of expenses done by the employee for the company is not taxable. Amounts paid by an employer as a gratuity or for a registered pension is not taxable. Education fees paid through employee income that the employer pays is not taxable. Now, payee in relation to non-Kenyan citizens. Non-Kenyan citizens are exempt from payee taxes in conditions where they are in Kenya to serve an employer solely and on passage between Kenya and places outside Kenya. For example, a truck driver is driving through Kenya going to Congo, all right? And then you pay them when they are in Kenya. KRA cannot tax them. KRA can, anyway, how are they going to collect the tax when the person has no KRA PIN? So yeah, they are exempt from payment as long as they are in transit. But if they are employed here, they must pay the tax. We have a number of other benefits that an employee can get from a contract of employment. We have educational assistance, mobile and internet allowance, a life insurance, accidental insurance, identity theft protection, financial counseling, discount on goods and services, workplace wellness programs. Some people are paid for the gym and counseling, and they are given given those kinds of programs. Pick up and drop facility for employees, dependent care assistance, employee meals, dental insurance, bonuses, and bonus compensations. Now, there are some employees who prefer to pay every 2 weeks. They don't want to pay at the end of the month, or they prefer to pay every week. Their salary can be, people's salary can be paid in intervals. They say, I give you advance. You know, there are some bosses who get angry because people did not take advance. I remember when I was employed many years ago, my boss used to ask me, why don't you take advance? I used to wonder, I don't need the advance. Why should I take the advance? So that I can be poor at the end of the month. And I always come back to the boss. Anyway, there are people who get angry when the employee does not take an advance. But there are people who prefer to take their advance, so pay them the advance. Date of which continuous service started. Like, for example, if you're paying every 1st of the month or every 30th of the month, it should continue like that, so that you know, it's easier for you. We have our terms of employment. Wait a minute. Okay. The terms of employment. These are very important terms in a contract of employment. Number 1, basic minimum wage. If you do not pay the person the basic minimum wage, they could sue you. And then you would need me to defend you, or any other lawyer in Kenya to defend you. Make sure you follow the basic minimum wage. This one is always increased on Labor Day. Last year, people were disappointed. Nothing was increased. They did not increase anything because times were hard for both the employer and the employee. And the question normally is, as an employee, you are asking for it to be increased. As an, what difference are you making to the employer once it has been increased? It should also contain working hours. How many hours in a week is the person supposed to work? It should include payment of overtime. Remember, any work above the working hours is subject to payment. All right? You must include a weekly rest, 1 day in a week. These ones, mostly people choose on Sundays to give the rest in a week. Holiday with pay. Public holidays are payable. If somebody works during the public holiday, you must pay them. If you don't pay them, they could sue you. The contract should also include annual leave, acting allowance, compassionate leave, sick leave, maternity leave. It should also include the aspect of redundancy. Talk about it in your contract. Don't just leave it open. Warning system. You must say how many warnings in your contract. It's important for you, because somebody can say, oh, I was given a warning last year. Now you've given me another warning and you've terminated me. It becomes a problem. Termination of employment should also be tackled. When does employment get cancelled? When does employment get cancelled? Now, all the terms we've discussed, the salary, the leave, and all that, it applies to 2 kinds of people who are the parties to the employment contract. The major parties of the employment contract are the employer and the employee. But there can be third parties. There can be third parties to these contracts. The contract can be extended to include other interested parties in the relationship. These include the government, which plays an important role by providing the minimum standards that govern the relationship through various labor laws. Now, why is the government important? It prevents possibilities of industrial confrontation between the parties. That's why we have the laws. Another interested group is employee trade unions. There are trade unions which are normally interested in the employment contracts of their members. The last important person in is the employer organizations. We have like the Federation of Kenyan Employers, Association of Hotel Keepers and Caretakers, and Employers Federations. These ones are also important. They are formed by employers to strengthen their bargaining power with both the government and employee trade unions. You're wondering who normally discusses the minimum wage? Before it is passed, there are organizations of employers that meet and discuss these things and then forward to the labor minister for them to now come and pronounce upon you, and then everybody celebrates, but they've already discussed it. Now, once the interested people have signed the contract, the employer, the employee, and then they've taken it to the trade union or the employer organizations, these contracts confer a right. They confer a right to the employer. Many people say, oh, these days, okay, it has changed a bit. These days, or those days when the act just came into force, the employment court Employment and Labor Relations Court was brought into place, and now everybody was saying this court is for employees. This court is for employees. It is for the workers. They were never giving decisions in favor of the employer. But these days, times have changed. I think even the employers have upped their game, because those days employees were suffering. Thank God I was not there. Now, what are the rights of an employer? The employer has the right to regulate working hours in accordance with the Employment Act. You cannot just be walking into your workplace anytime you want and leaving anytime you want. No, that is why people will call you. Your boss will call you and ask you, where are you? You're supposed to be. The employer has the right to receive personal services of the employee as per the contract of employment and the Employment Act. You must offer service to the employer, because why are they paying you anyway? The right to take disciplinary action against the employee as provided for in the contract of employment and the law. The employer has that right. The employer also has the right to terminate the services of the employee according to the contract of employment and the provisions of the law, which we shall be discussing in a few. So the employer also has rights. In as much as the employee has rights, of which the employee has many rights, the employer also has rights. You must serve your employer. Now, the employee has the following rights: to be provided with a basic minimum wage as provided under the law, to be provided with at least 1 day rest in a period of 7 days, to be provided with at least 21 days annual leave. These are now the rights of an employee. Female employees, you now know why I was saying you must state the sex of the employee when you're employing them. Female employees have the right to be provided with at least 3 months maternity leave if need arises. If need arises. 3 months maternity leave. The right to be provided with housing at the employer's expense or sufficient as rent, in addition to wages or salary, except where the wages of the employee already consolidates an element intended to provide them with housing and accommodation. You know where they say consolidated salary, consolidated wages, where they say your salary includes housing allowance. They are entitled to housing. Those days it was very easy. Many companies used to build houses for their managers and their staff. These days, even in hotel, getting staff quarters, we used to have staff quarters. Staff quarters, even governments used to give staff quarters to their employees. These days, even doctors being given staff quarters is becoming a problem. I don't know if we have very many or something, I don't know. The right to be provided with sufficient and wholesome supply of water for use at the workplace or near the workplace. Water. For example, in the coast, we have salty water. Now, it is water, but it cannot be consumed. It cannot be used. So, they need to include that. The right to be provided with sufficient and proper medicine during illness and possible medical attendance during serious illness. These days, many employers get insurance, medical insurance for their workers, so that they don't have to pay out of their pocket. Now, no contract of employment lasts forever. All contracts must at one time come to an end. People need to understand that. All contracts at one time must come to an end. It's important because there are some people who just want to work and work and work. And then when you tell them the work is over, they don't want to go. And then there's a problem. All contracts come to an end at some point. A contract may end because the parties have carried out or have performed all the obligations agreed upon. For example, if I give you a contract to construct maybe a house or a complex for me, once you finish that construction, even if it takes you 5 years, because I may be constructing at a very slow pace and I need an employee and I'm paying them per month, it is over. So people must go their separate ways. In this case, the contract ends because there is nothing else for the parties to do. Contracts of employment that terminate in this method are piece rate employment contracts. You know, like you're paid per piece. Kama imeisha, imeisha. Don't force. All right? Some contracts may come to an end because of frustration. Generally, frustration is a situation where a party to a contract is prevented from performing his or her part of the contract by circumstances outside his or her control. This in law, we call it force majeure, act of God. Act of God. For example, death of an employee. If the employee dies, there's nothing we can do. The contract has been frustrated. They cannot work. Sickness. Somebody can be sick for a month or 2 or 3, and then the contract has to come to an end if the organization doesn't have those policies that we'll be talking about in the next slides. Non-occurrence of an event on which performance of the contract was best. For example, maybe somebody has planned for an event, or they are bringing maybe who? They are bringing a celebrity to Kenya, and then they call people, come. Maybe somebody says, oh, like the other day, okay, not the other day, but like 2 years ago, Akon went to Uganda. And then Museveni said he's giving him a land so that he can construct Akon City. So, if they employ people and say, all you people, we want you to come and apply for these jobs because Akon is coming to construct a city, and he needs people to work in that city to do what and what. And then Akon, up to now, he has never gone, by the way, to construct that city or whatever he had asked the land for. So if he decides he's not going anymore, what happens? What happens? All the people, if they had applied, they have been frustrated. 2 years, they've been waiting 2 years. if it happened anyway, if they actually advertised for positions. But I know he's not gone there to use the land he was given for 2 years. I hope they will do something about it. So the contract will have been frustrated if they had signed it, hoping that Akon was actually going to come and make a city in Uganda and give them jobs. Passing of a law which makes performance illegal. Let's say, for example, the other day when we had the election campaigns, we had a candidate who was saying they are going to legalize some things. They were going to legalize some things. Let us say he had become president and legalized those things he said he wanted to legalize. Then many people get employed in that sector. Then another president comes and makes the things illegal and bans them and cancels everything. All the people who were employed when those things were legal are now left in the sun to try, because they will have no employment, because the things that they were doing have now become illegal. They can no longer do them. It's been frustrated. It's been frustrated. A contract can also come to an end when breach occurs. Breach is a legal term for breaking. I don't know why they had to say breach. Anyway, you know, the legalese, the lawyers, we like those things that other people don't understand. So yes, when the contract breaks, when one of them breaks the rules, it's called breach. So this is where a party to a contract fails to carry out his part of the contract, either fully or partly. It is the opposite of performance. So when either party breaches the terms of the contract, it will have to come to an end. Resignation. Resignation. Resignation is where the employee gives notice to the employer that he or she shall cease to be an employee from a particular date. The length of the notice may be agreed by the parties or imposed by law. Where there is no period of notice, any reasonable period may be accepted by law. Reasonable. Reasonable. Now, that is why when you're doing the contract, it is important to put notice. And I see many how do they call it? Collective bargaining agreements. They normally have that term, whereby they say if you want to terminate somebody, you must give them a notice or pay them in lieu of notice. Employees don't like to pay in lieu of notice when they have resigned. They just want to tell you today, oh, sir, from tomorrow, I am not coming. And then they don't pay you. Okay. If you make the mistake and tell them, excuse me, from tomorrow, don't come, the number of fights you will receive, the court cases you will receive. Hey, but for them, they just want to wake up in the morning and tell you, hey, excuse me, I have resigned. Sue them. The same amount of notice they need is the amount of notice you need. Because where are you going to get somebody to fill their position instantly? Where are you going to get the person? So, can an employer refuse to accept a resignation? If somebody gives you a resignation letter today, can you refuse it? Can you refuse it as an employer? Well, generally speaking, you normally. Resignation cannot be refused. Generally, the general rule is you do not refuse a resignation. Anyway, how will you force this person to work if they don't want to work anymore? Remember, they are giving you service. How are they going to work? but you can refuse a resignation in certain conditions. An employer can refuse a resignation of an employee in certain conditions. In certain conditions, an employer can refuse resignation of an employee. Those conditions are very specific. Why should you refuse a resignation of an employee? There are those tasks that nobody else can fulfill. Like maybe somebody was supposed to construct a bridge, all right? So, okay, now that one is a bit difficult to explain. It's a bit difficult. Like when the person resigns, nobody else can be able to fulfill that task. That's the only person who can fulfill it. They must do it. So you can refuse. You can say, no, you're not going to resign until you finish this. Finish this one, then you go. Finish this one, then you go. You can refuse the resignation. Also, an employment contract can come to an end when there is dismissal. Dismissal. Dismissal is a process by which an employer terminates a contract of employment owing to the fault on the part of the employee. Owing to the fault on the part of the employee. There are 3 forms of dismissal, namely by warning, 2, summary dismissal, 3, by notice. For example, you can just say, you did not do this well. For that reason, I'm giving you 1 month notice. Starting on this day, your service will no longer be required. The cases in court, most of them are from dismissals. Nobody wants to go home. Nobody wants to leave the money. When they were doing the wrong thing, they were not thinking about the money. But now that they've been caught doing the wrong thing, they now know the money is very important. Many cases in court arise from dismissal, especially summary dismissal or dismissal after notice has been served. We will go into the remedies shortly. So another thing that can cause a contract of employment to end is redundancy. Redundancy is a situation where the employer has more labor than he needs. Where this is the case, the employer may get rid of some employees. You know this thing called layoff. Oh, the government has laid off its workers. You know, those days, it was very bad. It was very bad. They would wake up in the morning and then they say, we have laid off 500 workers. What are they supposed to do? We no longer need them. We no longer need them. That is why it's important to put a redundancy clause. When we had the COVID in 2020, many people became redundant. Many people, because there is no work, especially in the hotel industry. Many people became redundant. And then what happened? Zoom was introduced. Microsoft Teams was introduced. That is why we are here. You people are in your house, you're in your car, you are in your office, you're anywhere you want to be. Me, I am here talking to you. I don't even know whether you are listening or not. Many people were rendered redundant. All the people who were in the hotels. For example, if this training was at a hotel, 82 of you, I see 82 participants right now. 82 of us would be drinking tea. People would be employed to serve us tea or bread or bake the bread or even make the tea. Now Zoom came. Many people became redundant because of technological advancement. What can the employer do? What can the employer do? They just have to lay off the people because there's nothing they are doing. You know, There's nothing they are doing. Something else that happened, the courts went digital. Those days we used to move. You spend 6 hours on the road going to a court in Migori, going to a court in Kisii, going to a court in Busia, going to a court in Malindi, you know. You even have to be paid for the flight. You get free holiday in Malindi. Okay, right now, we just enter the computer. You tap, as the president says, you just tap and get dollars. You just tap the screen and you do what? You speak to the judge. In 5 minutes, you're done. Something that would have taken you 4 hours, you're now doing in 5 minutes. What happens to the clerks in the offices? The ones who used to be sent, they were declared redundant. These days, even recently, the court said they are now going to bring Huduma services, the court services to Huduma Center. All these people that were running around at the printer, at the whatever, what is going to happen? There's no more work. There's no more work. So what will the employer do? They'll tell them, please go home. There's no work for you. Because things that we needed 20 people to do now are being done by one person. And in recent times, there has been a new technological development, AI, artificial intelligence. It is also driving people out of work. Artificial intelligence has come and it is with us and it is here to stay. It is here to stay. What is going to happen? People are going to run out of jobs. There will be no jobs for people to do. So what will happen? The employer will tell them, go home. I don't need you. If I need to do research, I don't need to go to the library. I just ask AI. There are so many AI developments now. Just ask AI. It will tell you everything. Many of you, the jobs will go. Of course, we'll have many cases in courts. As the lawyers, we shall be happy because we'll have work. But with these new developments, many people are becoming redundant because robots are taking over. Artificial intelligence is taking over. Zoom has taken over. Teams has taken over. Everything is taking over. Machines, they are taking over. What will happen? We can say, oh, we get one last case. I don't know, because the AI will not sue the employer. The AI will not sue the employer, oh, you fired me. No, it will just be put down, closed, finished, end of the case. Retirement. Every employee whose employment does not end in other ways may be eventually become old so that he cannot continue working. So in practice, every contract of employment is bound to be ended by old age. If all these things do not happen, we are not computer. Even the computer grows old anyway. We are not artificial intelligence. Maybe at some time it will also grow old. We will grow old. We cannot work anymore. I cannot sit here on the screen and be talking for 3 hours anymore. So what will happen? I will retire. Retirement is a situation where a contract of employment is terminated by the employer due to old age. That is the idea. According to the employer, after a certain age, the efficiency and productivity of an employee happens to decrease. There is, however, no one age which an employee must retire. For example, the other day I saw an advert in the internet where they were advertising for 5 high court judges, 5 high court judges, and they say retirement at the age of 60 with an option of choosing 50. And you can also increase age of retirement. Actually, one of the professions whereby they even want you more when you're growing old is law. Because you have attained so much knowledge, they think if you retire at the age of 60, they are losing out. 60 years of legal knowledge is a wealth of knowledge. That is why you see very old lawyers still working. Like the very, very senior lawyers like Haminwa. He's very, very senior in this profession, but people still go there. Maybe he's not able to type anything on the computer, but he has got a wealth of knowledge. You find the judges of the Court of Appeal, the judges of the Supreme Court, they can grow very old, but they have a wealth of knowledge. We can see doctors. Okay, now the technology has also overtaken the doctors now, because the young ones are the ones who know the new medicine. The old doctors, they'll just give you that old medicine, and maybe it's not working anymore. The germs have the germs have improved their skills. The bacteria has improved their skills. Then they give you old knowledge for a long time ago. I think it's only the law that has not changed much. Even when it changes very little, very little. That is why old lawyers are still encouraged. Otherwise, would be retiring, you know, at a very high rate. People like the older the lawyer, the more the law they know. The contract can also terminate in cases of death. Death is an event which stops a person from performing his part of the contract. Therefore, where an employee dies, the contract of employment is frustrated and comes to an end. Lapse of time. Lapse of time takes place where the fixed period of time has expired. We said to do this in 3 hours. My contract is for 3 hours. So once the 3 hours are gone, tunamaliza. The contract expires. It is for time lapse. Anyway, if at all it was an employment contract. In Aisha. Now, we want to move to the aspect of change of employer. You're wondering, when it comes to gratuity, does change of an employer mean that the continuity of employment has broken? The general rule is once the employer is changed, the continuity of employment is broken. This comes into play at the point of calculating gratuity. Yes, sir. It comes into play then. Because, for example, these days we have, especially the collective bargaining agreements, they talk about gratuity. The years of service, you must calculate for them when they are now leaving service, and then you pay them. There is an exception for the general rule. In cases of transfer, maybe you've been working in Kwale for 2 years, and then your boss was different, then they transfer you to work in Busia. Or maybe you've been working in the, as a secretary, right? And then you are transferred to another branch as a office administrator. I think it's almost the same thing, but yeah, you have become an office administrator in Malindi from Kwale. There might be still a continuity of employment. In cases of mergers and acquisitions, for example, if Safaricom decides to buy, no, let me not use Safaricom. They will say, I don't like that other, network provider. Let's say if Toyota Kenya decides to buy DTDobi, all right? DTDobi already has its employees and probably branches all over the country. Toyota Kenya decides to buy it and take over everything. If they decide not to drop the employees, or if they decide not to sign new contracts, the time of employment will continue. This is relevant for calculation of entitlements to benefits, like gratuity or service pay, if, you know, if that happens. So if there's a merger or acquisition, or maybe let's even say Toyota Kenya and DTDobi merge, they become one and become CIAO, something like that, motors. The contract of employment may still be considered to be continuing until that time when maybe it terminates, and then you need to do the calculations. Now, we are moving on to terminations and dismissal. Termination and dismissal. This one is covered by Part 4 of the Employment Act. Termination, it has to do with all those things we've been discussing. You know, automatic lapse, redundancy, death, illness, and the monster is dismissal when there is misconduct of an employee. Many people, that's the only area they focus on. They don't focus on these other things. They just want to know when is it okay to go to court. They just want to know when to go to court. In case the term has not come to an end, but one party wants to terminate, they must give notice as prescribed in the contract or of employment or in accordance with a CBA. For example, there are some CBAs that say you give notice of 4 months, or contracts that say you give notice of 2 months, 2 months or 1 month. Follow those. If you are tired, give notice to your employer. If you're tired of the employee, for good reason, give notice. 2 months according to your contract, or 4 months according to the CBA, give them notice. Where notice is not given as prescribed, either party has to pay in lieu of notice. If you do not give notice of termination of contract, you must pay that person that money. For example, if they are earning 50,000 and you want to terminate them, you give them 100,000, and hopefully they go home. Some refuse. They say, I'm not going anywhere. I'm suing you. I still want to work. We've already discussed resignation. So, in case of termination, what is somebody entitled to? What is somebody entitled to? Number 1, service pay for every year worked. That is why we were talking about continuity in the previous slide. Service pay for every year worked. That one is calculated half salary of a month. For every year, you get half salary. You get an equivalent of half of the salary per month. So if you've worked for 15 years, they will go to each year. How much were you earning this year? Because it cannot say, oh, you were earning 50,000 for 10 years. No. Of course, there was an increase and all that. So they will calculate per year how much you were earning, and then they'll do half of that for each year. Service pay is not applicable for persons in a pension fund to which the employer is contributing. It's not applicable in case of a gratuity fund or a fund established by a CBA. It's also not applicable where the employee is part of NSSF. Now, NSSF problem. NSSF has got problems. Last year, there's a problem with NSSF, and the government decided now these things are no longer there, NHIF. They went and created other things. What happens? What happens when now they create other things? What happens to the old things? Where does the money go? And what happens to service pay? Anyhow. Now that you know what is supposed to be paid in case of termination, we have cases of lawful termination. When is it considered that you have terminated somebody's services lawfully? In case of misconduct, the Employment Act specifically defines misconduct as Absenteeism without leave. Somebody decides to disappear for a week. They didn't tell nobody. They did not communicate. They didn't send an email. They were not in a coma. They were not involved in an accident where nobody knew. They just decided not to come. And then after 1 month, they show up. After 1 month, they show up. Actually, some CBAs, they specifically provide, if you're absent from work for a week without leave, without any information, without telling anybody, you have already dismissed yourself. So what the employer is supposed to do is write a letter specifying you were absent from work between this day and this day. For that reason, it is over. Intoxication while on duty. Intoxication while on duty is a very interesting aspect. Because there are some people who say, I work better when I am a bit intoxicated. There are those kinds of people. There are those kinds of people. So, intoxication will be considered as a misconduct if the level of intoxication prohibits somebody from performing their duties. Performing their duties, all right? Which now makes me skip to this other point, use of abusive language at work. They may be working very well, but they're abusing everybody at work because they are intoxicated. Problems. That is where the problem is. So somebody may say, oh, me, even if I'm drunk, I work very well. I work very well. And then they come and abuse everybody. It can also be a reason for termination. That's considered to be misconduct. Negligence of duty. Some people just don't do their work. They come to office, they are just on the internet, they are just in the Facebook, they are on the TikTok. These days, I normally see people are in office, but they are not working. They are on TikTok, they are on Instagram, they are on YouTube, they are on Facebook, they are playing Candy Crush. They just don't do nothing. And then on 30th, they want their money. That can also be, it's also a form of misconduct, negligence of duty. If you don't do your duty, you are a nurse. You're supposed to be attending to the patient, giving them medicine, and you're busy playing Candy Crush. The patient is in pain. They have not taken their painkiller. You've forgotten to give them because you're busy doing other things. It amounts to misconduct. Refusing to obey lawful instructions. Refusing to obey lawful instructions. Have you ever seen a case whereby somebody was fired for insubordination? That word, sometimes it is misused. Somebody is fired for insubordination, refusing to obey lawful instructions. Now, the instructions must be lawful. There's a case I saw. Somebody was a chef. Now, this chef was told to clean. The person refused to clean. So that's not my job. That's not my job. Should that person be fired or not? Should that person be fired or not? Is it misconduct if you're a chef and you refuse to clean? Okay, let me specify further. If you're a chef and then you refuse to go clean the toilet, is it misconduct? Remember, that is why we said in the beginning, it's important to have a description, job description. What have you hired this person to do? Have you hired them to be a chef or have you hired them to be a cleaner? Mary, kindly mute. Mary Kaibere, kindly mute. Thank you, Mary. All right, conviction in a court of law. Let me tell you what happens. Let me tell you what happens. Let me tell you what happens. When somebody has been convicted of an offense in a court of law, It is considered as misconduct, so you can terminate. But let me tell you what actually happens. It's unfortunate that it happens. If you're doing this, you should stop. When the management wants to get rid of somebody, they go and report a case to the police. They go report a case to the police against the person. Then the police collects the person, does investigation, then they put them on half pay or unpaid leave until the matter is resolved. Now, this person is not at work for probably 2 years or 3 years because the criminal case will take so long. Criminal cases really take a lot of time. They take so long to be resolved. So the person is out of work for 2 years. Who is doing their work for those 2 years? Who is doing their work? Of course, there's somebody doing their work. And what are they going to be doing with themselves if they've been given the bail and they're out on bail? What are they going to be doing for 2 years? Of course, they look for other employment, right? Right? So, unfortunately, if they are convicted, then they don't pay nothing. They don't pay. They say they were convicted, misconduct. If, fortunately, they are not convicted, what happens for their lost time for 2 years? Now, what happens in a case whereby it's not the employer who has reported a case, but this person is convicted? For example, the person goes and steals at night and then they are taken to court and then they are convicted and then they are told to serve 2 years in prison. What happens? The contract is terminated. What happens in a case where they are told to pay a fine for something that they did not do at work, but they are convicted and they are told to pay a fine? For example, a simple traffic offense. They are convicted to pay a fine of 15,000. Should they be terminated from their work? They need to be specific on this type of misconduct. For conviction in a court of law, somebody could be convicted for driving badly or for being idle and disorderly. Okay, that was removed from the law because so many people, or for being drunk and creating disturbance, drunk and disorderly, and they are convicted. Should they then be fired from work because of that conviction? I don't think that is the case. So, if you must fire somebody, if you must dismiss somebody, issue warnings. Issue a warning. That is why we said when you're drafting your contract, it is important to put the system, warning system. How many warnings suffice? How many warnings suffice for a dismissal? Put it in your contract so that somebody knows from the onset. Don't say, oh, we have a policy somewhere that somebody has never read. We have a policy in the file in the HR's office that if you're given 3 warnings within a year, you must go. Put it in the contract so that when you're taken to court or when you're taken before a dispute resolution, alternative dispute resolution, or when you're taken to the labor officer, you have a ground. You say the contract says we are giving 2 warnings. If you get 2 warnings in 6 months, you go. If you didn't have it in your contract, then you will be trying to prove that this person has actually read the policy. When did you give them policy to read it? Which notice board you put it on? Are you sure they read it on the notice board? And all that? So it will save you the trouble. All right? Now, issue a notice to show cause in writing. If somebody must be dismissed, issue them with a notice to show cause and allow them time to respond to the notice to show cause. Let them give reason. There is There is a problem that I see with HR managers. You issue a notice to show cause, and in the same letter, you are calling somebody for disciplinary hearing. Jen, kindly mute. Jen, kindly mute. Jen, kindly mute. Jen Kenders, kindly mute. Or am I able to mute you from here?
Okay.
Okay, yeah, I've muted you. It's okay. It's okay. I've been able to mute you. The HR manager will issue a warning, and it is the notice to show cause, and it is the disciplinary hearing notice. It's wrong. Why are you in a hurry? Why do you want to get rid of this person very eminently? Why? Many HR managers are in a hurry to dismiss. They just want everything done within a week, finished. Even the appeal, finished. So, issue a notice to show cause in writing, allow the employee time to respond. After they have responded, if you're not satisfied, because the notice to show cause is show cause why you should not be subjected to a disciplinary hearing. How can you now issue a notice to show cause and you're already calling them for a disciplinary hearing? Does it make sense? Doesn't make sense. Issue the notice to show cause. After that, issue the letter for disciplinary hearing. What if the person explains themselves in the letter and it is satisfactory and you've already issued a disciplinary hearing date? It doesn't make sense. So after you issue the disciplinary hearing letter, you should hold an actual disciplinary hearing and hold it in the proper manner. Let them, in the invite for the disciplinary hearing, let them know that they are allowed, they have the option to come with another employee of their choice. Make sure that employee of their choice is not a member of the work of the, how do they call it? Of the work, how do they call it? Those things in the CBA. Works committee. You know, there are employers who say, oh, you know, there was an employee in the meeting. That one is a member of the works committee. No, they are supposed to come with another employee of their choosing to the meeting. Put it in the letter. On such and such a day, you are invited for a disciplinary hearing starting from 12 noon to 3 p.m. And you are at liberty and highly advised to come with an employee of your choosing to the disciplinary hearing. During the disciplinary, this is what makes HR managers be brought to court. And many of them don't want to come to court and testify. They don't want to come to court and testify because they did things in a hurry and now they are regretting. They didn't expect this person would go to court. So now that they're in court, they are trying to get excuses from everywhere why they should not come to testify. So, the disciplinary hearing, at the disciplinary hearing, do proper minutes. Do proper minutes of the disciplinary hearing. All right? Do proper minutes, and minute number 1 or number 2 or number 3, of course, you'll do introductions, who is present, blah, 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 blah. Minute number 4 or 5, put, we asked so-and-so why he did not come with another employee. It is important because it will be used against you. It will be used against you. If he comes with another employee of their choosing, right, XYZ came with ABC, and the ABC person attended the meeting and witnessed whatever happened. Most likely, the employee, if you dismiss them, they will not sign the minutes. They will not sign the minutes of the disciplinary hearing. So who will sign these minutes? The extra employee who came with them, if they are still in your employment, will sign the minutes. You know? But now, you did not tell them to come with an extra employee. You did not ask if they came with an extra employee or not and why they did not come with them. You have nobody to sign the minutes. Then at the court hearing, the person will say, I was not given the minutes. I do not agree. I've never seen these things. What will you do? What will you do? Your organization will be made to pay, and you will pay. And the organization will lose. You know, after you've done the hearing, issue a recommendation of the hearing and resolution. Issue the recommendation. Issue a recommendation. At the end of the minutes, recommend either for the person to be fired or not. If the person is to be fired, inform the employee, write in the letter, pursuant to. Now, this one is what will save you in court. This is what will save your face in court. Pursuant to the notice to show cause, you wrote a letter dated this and responded. We were not satisfied. We called you for a disciplinary hearing. On the disciplinary hearing, you presented this and this. You came with so and so. You gave your reasons why you should not be terminated. Your reasons were not satisfactory. For that reason, we have resolved to terminate you. You have a right to appeal within a period of 14 days. All right? Make sure you put it in your letter, because if you don't put it in your letter, in court, the only thing they will say, I was not informed of my right to appeal. That is what they will say. I was not informed of my right to appeal. But if it is in the letter of dismissal and they do not appeal, you are safe. If you do not write it, you are doomed. You will be in court, or you will refuse to come to court to testify. So save yourself. Save yourself. Save yourself. All right? So, that is it for the termination and dismissal. At this point, we are going to discuss a little bit, well, some of the things we've already talked about in the previous slides, but people still like to hear them, because if you don't mention it, they will say you did not say it. Just like if you do not mention in your letter that you have a right to appeal, they will say, I was not told that I have a right to appeal. You know? So, we are going to go to the famous legal notice number 28. Famous legal notice number 28 of 2014. Many people, they like to hear legal notice. It's just the things we've been discussing. It's just the things we've been discussing, but now, because it was popularized as the legal notice number 28 of 2014, we have to say it. We've discussed all these things. We discussed all these things, but it is important for us to say legal notice number 28 of 2014, which establishes the rights of employers and employees that we've said up there. You know, the act was not so clear when it came into force in the Act of 2007, which came into force in June of 2008, right? They were not clear on some things. I think they drafted it in a rush, and then they went to clear the air. Many questions came up. 7 years later, they went back to the drawing board and tackled the things that they had not talked about. It establishes paternity leave. Before, there was no paternity leave. Now, in 2014, they said, look, wait a minute. I think now, let me tell you what could have happened. In 2007, probably not very many women were being employed. Probably many women were staying at home, looking after the children. But now by 2014, many women were in employment. They needed help from their husbands, at least for the first 2 weeks or the first month. They cried. Okay, I was not there, but I'm thinking. They cried and said, look, we need help from our husbands. They are disappearing from home. They are saying it is work, 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 work. We need them to be home. to also take care of the children a little bit, or to help us with other things that we take care of the children. So they gave the paternity leave, 2 weeks paternity leave. Now this paternity leave is 2 weeks per year for a male employee, 2 weeks in a year. If you have 3 wives and they are most likely to give birth in 1 year, take 4 days for each. Take 4 days for each so that you can distribute properly. 4 days times 3 is 12. Then you have 2 days to spare in 1 year if they are likely to give birth in the same year. If you have 1 wife and she gives birth, take 2 weeks. Now, it's a tricky situation. Now the HR will ask, how will I know that it is the wife who has given birth? How will I know that is the wife? That's now your business. That's why it's important in the contract. And when they are filling the forms, make them disclose. Are you married? That's why they ask marital status. Marital status, if they say single and they've never updated, how are they asking for leave? And they've said they are single. Anyhow. The legal notice number 28 is the one that established employment for persons below the age of 18. The one that we were discussing, age 16 and above. It was brought about by legal notice number 28. It also brought the rules about sanitation, where you have to provide toilets and the distance between the toilets and where you are supposed to do to be working. It also brought into place medical treatment, where the employer is supposed to provide medical treatment. All right. It also brought in the rights during termination. When termination occurs, this legal notice number 28 is the one that spelled out the rights when termination occurs. It's the one that did this. It is the one that spelled out the itemizations of the payslip. It was not there in the Employment Act. It also brought about wait a minute. It also brought about the aspect of giving transportation. It also brought about the aspect of foreign contracts of service. You know, like if you're employed on a ship and you go to work abroad, maybe you are in Kenya, your employer is in Kenya, then they take you as an expatriate to another country. You are protected under the laws of Kenya, all right? It brought about all these basic rights of the employee, all the basic rights were brought about by this legal notice number 28. It is the one even which brought about the area we were discussing on the terms of a contract, what must be in a contract, dismissal, rights on dismissal, rights of a child employee. It is the one that brought about all these aspects that we've been discussing, because the 2007 Act was just plain, was just the Act. They had not thought everything through, and now they brought it clearer in the legal notice number 28. It also brought about the aspect of advertisement for employment. It also prohibited the forced labor. Most of the things we've been tackling, the rules of employment, were brought into force by this legal notice number 28 of 2014. All those things we've discussed above, right? We now have, we had an Employment Amendment Act of 2021, which establishes the pre-adoptive leave. Pre-adoptive leave. Now, the makers of the law realized that not everybody gives birth naturally. Not everybody is able to have a child of their own. So they brought an aspect of adoption. What happens in a case of adoption? Where, pursuant to Section 157 of the Children's Act, a child is to be placed in a continuous care and control of an applicant who is an employee under the Employment Act, the employee shall be entitled to 1 month's pre-adoptive leave with full pay from the date of placement of the child. This works in cases of adoption because they have the right to bond with this child. I mean, this child is coming in from somewhere, from a child care center, pursuant to a court order. Because adoption is not something you just go pick. You know, in Africa, you could just go pick the child of your sister and stay with them, and then they are considered your child. Those days, before things became complicated. Nowadays, things are complicated. You cannot just take somebody's child and you're living with them because you have money and your sister does not have money. So you now take the child by force. I think they realized many people were making the children suffer. So they made the rules a little bit strict. So where there is a court order or for adoption, for placement order, you know, the adoption process is very long. I will not go into it because we are discussing employment. It's a very lengthy process. But where finally the child is being placed, the parents are supposed to bond with this child. So they need time. That is why they now created this rule. An employee entitled for leave under subsection 1 shall notify the employee in writing of the intention of the adoption society to place the child in the custody of the employee at least 14 days before the placement. Remember, adoption does not just happen overnight. It is a process. So nobody can tell you, oh, I didn't know the child was being brought. They know. They know. So they must bring supporting evidence that indeed a child is being placed in their care. Because it's not something you just wake up and say, oh, a child is coming. No, it's a process. There are letters that are written. There is investigation that is conducted. So they put the child in the care of this person to test and see how are they relating. Are they compatible? Because this is not somebody they gave birth to, so they need to test that. So the person applying for the leave must do it in writing, and of which they must attach the documents from the adoption society, because they are always notified. A notice under subsection 2 shall be accompanied, I went ahead of myself, by documentation evidencing the intention of the adoption society to place the child in the custody of the employee, including a custody agreement between the employee and the adoption society and an exit certificate. Don't be twisted as an HR manager. They may think you don't know these things. I'm telling you for free. The letter must come with the intention, the evidence of intention for the adoption society to place the child in the custody of the employee. And there must be an agreement, because they are not going to just give this person the child for the whole month. No, there's an agreement. The person is supposed to report to the adoption society. Maybe after a week or 2 weeks, there's normally an agreement to check on the child. And then there is an exit certificate. What if the test does not work? You know, so they cannot tell you, oh, I've just brought the agreement. There must be an exit certificate, because it's not in all cases that adoptions work. Sometimes it may not work. So there is going to be an exit certificate. All right. So in 2021, they just changed that. They just brought the pre-adoptive leave, and that was it. Now, there is another one in 2022. There's another one in 2022, the Employment Amendment Act number 15 of 2022. They can even do an amendment and just change one section of the act. They just change it or add something like that one for the adoption, pre-adoptive leave. They just changed section 29 and then they just added that on section 29, you know? Now, in 2022, another section of the act was amended. Section 9 of the Employment Act is amended to insert the following new subsections immediately after subsection 4. In respect to recruitment, an employer shall not require an employee to submit any clearance or compliance certificate unless such employer intends to enter into a contract of service with the employee. There is this thing that they were doing. I don't know if they still do it in the government. When you're applying for a job, they tell you bring tax compliance certificate, bring clearance from is it? What is that thing where they used to blacklist people who have loans? Credit Bureau. I think it was the Credit something Bureau. Bring that one. Bring police clearance, good conduct, yeah? Certificate of good conduct, blah, 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 all those things. Then somebody will be spending a lot of money to acquire all these certificates. Bring the certificate from your former employer. So you spend a lot of money and time to go and look for these things. And then they don't employ you. You spend 20,000. You're trying to get a salary of 50,000 per month. You end up spending 20,000 looking for certificates on transport, on what. You know how Kenya is. You spend 20,000, you make application. They don't even call you for interview. So I think people complained because why are they spending all this money and they are looking for money? They are spending money looking for all these compliances and blah, 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 and then they are still not getting employment. That's a waste. It's a waste of resources of the citizens. So it has been changed. When recruiting, an employer shall not require an employee to submit any clearance or compliance certificate unless such employer intends to enter into a contract of service with the employee. Right? Provided that an applicant for a state office shall provide compliance or clearance certificates at such time in recruitment or approval process as they may be required. So it doesn't mean that they are exempted. Now this one is referring to state office. I knew it because these government organizations are the ones that are, government agencies are the ones always asking for these things. They are just asking for everything. People are looking for jobs. Now you're making them spend money by asking for so many things, and then you don't even call them for an interview. So at the time of recruitment, they can ask you for these things. You know, you don't attach everything to the application. People used to suffer a lot. It's a good move. Whoever thought of it, it's a very good move because people were suffering a lot with all these attachments. An employer who intends to enter into a written contract of service may, in compliance with Chapter 6 of the Constitution, request an employee to submit mandatory clearance certificates from relevant entities. You know, they even used to go to, is it anti-corruption? ESCC certificates, all kinds of certificates. So now, they can ask you to provide them at the point of recruitment. It's a very, very good move. Notwithstanding subsection 6, an employer may, where the employee does not satisfy the requirements under subsection 6, withdraw an offer of contract of service. So maybe you've been given this job. You've been given the job, or you are about to be given the job, and then they tell you to provide the certificates and you do not give them the certificates. They can withdraw the offer. Remember, at the point of contract, when they present to you the contract document here, we are giving you employment. It is an offer until you sign, until you accept the offer. So they may give you the paper, say, this is your contract, subject to you providing us with the following certificates. If you do not provide the certificates, the offer can be withdrawn. They can take it back if you do not have it. All right? A relevant public entity shall not charge a fee for issuance of a clearance or compliance certificate under this section or any other written law. Okay? How practical is this? How practical is this? Are they still charging for good conduct? I've not applied for one. How are they still, if you know the answer to this, I'm not sure. Do they still charge money for issuance of good conduct? Because
Yes.
they are still charging money. Why?
Yes.
You should show them this one. Do they know that the act has been changed?
You apply on the system, so you are charged for it.
But the act has been changed. They need to remove it. These government people, they cannot be changing here on paper, and in practice, people are still paying. It is here. The relevant public entity, it is specifically referring to public entity, shall not charge a fee for issuance of a clearance or compliance certificate under this section or any other written law. They should be like KRA. When you apply for tax compliance, or as long as you've paid all your taxes and they do not have, there is no debt on their end, they just issue you. So I think the Uduma people need to change this. They shall issue an applicant with a clearance or compliance certificate or reject the application within 7 days of receipt of the application. How practical is this? How long does it take to get a good conduct certificate?
Nowadays, 4 months.
2 months. And look at the law. Look at the law. It says maximum is 7 days. I don't know how practical this is. I don't know how practical this is, but this is a new thing. It came into force just the other day. It is written 2022, but it didn't really come in force in 2022. It came in force in 2023. So I hope they will change. I hope they will change these things. When this Amendment Act says an employee means an applicant for an employment. Employee is applicant. It doesn't mean that they already are employed. Employer includes employment agencies when it comes to this amendment. So they've changed that a little bit. Finally, this is the final one. This one has not yet been passed. It is a bill in Parliament. It came to Parliament in 2023, and it was brought by the Honorable Dismas Wekesa Barasa. What do they want to change? What do they want to change? They want to change aspects of transfers. I think this one is also targeting the government people, because for private organizations, here you cannot force it. This one is also targeting the government entities because people were being frustrated. People were being frustrated because of these transfers. Employees can request for transfer from an employer. That is what this is in just a nutshell of what it seeks to bring into force. Now the employer can receive a letter from the employee saying, me, I want a transfer, and I prefer to be transferred to Busia. Why? That employee must give reason why they need the transfer. They must give a good reason why they need transfer. They must, the employer must inform the employee of the implications of their transfer on their contract. Okay, I beg your pardon. Now this one, in a case where the employee is not asking for the transfer, when the employer wants to now transfer you, for example, you've been working in Kwale, and the government says, now go to Busia, they must tell you the impact of your transfer on your contract. Is it going to continue as it was? Are you going to be increased salary because you've gone on transfer? All those things. The employer, I beg your pardon, the employer must notify the employee of any measures that the employer envisages shall be taken in relation with the employee. That is the, like, what will the transfer help you? How are they going to change things when they transfer you? They must, now, this is interesting. This bill seeks to impose this on the employer, that before you transfer somebody, you must get the consent of the employee before effecting the transfer. So there won't be, if it is passed, there won't be anything like you've been transferred with immediate effect. They must tell you, we want to transfer you to Busia. What do you think? Or what do you say? They must get your consent. Is it even practical? Especially with government agencies? I doubt that. I doubt that. Considering that they signed the agreement saying they are going to serve anywhere in Kenya. Even if Kenya now moved to Ethiopia, in case we wake up and we find that Kenya has moved to Ethiopia, they took the agreement, they signed the agreement to say they will serve anywhere in Kenya. Where it is applicable, they must facilitate the movement. They must facilitate movement of the employer to that place. That is in a nutshell. That is what they want to achieve by this amendment bill. We have 15 minutes for the Q&A. I will go to the chat to see if there's any question in the chat. Emmanuel Gikombo, sorry, Emma, not Emmanuel. Emma Gikombo asked, on fixed-term contracts, how soon can one issue a new contract after expiry of a current one? For instance, if the contract expires on 31st, should the new contract be from first or some days later to avoid claims of continuous permanent employment? Now, normally, when you're drafting your contract, now that goes back to the draft of the contract. When you're drafting the contract, there are some people who put a clause that says, if either party wishes to renew the contract, they must give a notice in 3 months notice of intention to renew the contract. For example, if the contract expires on 31st of January, it is advisable to give a notice of intention 3 months before or a month before, depending on how you want to do it. All right. So if you want to avoid the issue of continuous permanent employment, you can give the notice and say the new contract will start 14th of February. We intend to renew the contract starting this. I don't know how applicable or practical it is with the organization, because who will be doing that work when the contract has expired and you don't want to renew immediately? Who will be doing that work? It's neither here or there. Anthony says, in judiciary, they used to employ judges from Commonwealth countries. Justice Aquilano Molade Akwimu. Oh, that's nice. I didn't know. Thank you for that. Thank you. I'll do more research on that. So we have somebody saying they used to employ people from abroad, from Commonwealth. Okay, so I stand a chance. I can apply to be Supreme Court judge. Anyway, that's on a light note. When an employee is in a relationship with a supervisor and the relationship ends, how do you draw the line between personal relationships and sexual harassment? Now, in most organizations, there is a policy prohibiting relationships. That is why you must have a sexual harassment policy and have a policy. It's normally advised to have a policy where you are not allowed to date within, because it causes a lot of confusion to the detriment of the employer. And sometimes it's hard. It is hard to deal with this issue. It can be very difficult, by the way, sexual harassment. That is why most organizations refuse. They do not allow dating. They do not allow relationships between parties in the same organization, because it can be a very bad situation. When you don't intend to renew an employee's contract, do you give them a notice, or the contract end dates can be seen as a notice? There is no notice because the contract period has ended. Why do they need the notice? Why do they need the notice? They don't need the notice because the contract period has ended. If it is done, it is done. No need for notice. That is how it is. That is how it is. There is a wait a minute. Wait a minute. Can date of birth suffice as age requirements? Yes, it can suffice. Thank you so much. Are bonuses taxable? Bonuses are taxable. It is profit from employment. They are taxable. On holiday pay, can I give a day off instead of pay? No, but they worked on the holiday. You cannot give a date off instead of paying. They worked on a holiday. Kindly comment on payment of terminal benefits in case of death in service where next of kin and nominated beneficiaries are listed. The role of labor officer in payment of terminal benefits. Okay, in case of death, actually what normally happens, the person who is nominated is supposed to be paid the terminal dues because that is it. But sometimes, what if the person, it's normally very difficult there. If the next of kin has been listed as a person nominated to receive the payment, that payment should be done because most times it helps the family to offset the debts in cases of death. I'm trying to go through the questions within the remaining time. Sorry. Somebody is asking, is it correct to summary dismiss based on conflict of interest? An employee who works as a debt collector then proceeds to open a debt collection company where he is the director but claims he has not referred any debt collection cases to his company. It is not listed as one of misconduct. You remember, summary dismissal is in cases of misconduct. That one, you may have to go to court for it if you summarily dismiss. You must give them a show cause and then go through the process and prove that indeed they are having the conflict of interest. There's a conflict of interest. Zipporah was answering Anthony, saying, Anthony, you can tell the employee to stand on his or her 1 feet, and if drunk, definitely they fail the test and take the video of him. When worse gets to worse, alcohol tests and take a picture of it. That was in relation to employees who come when they are drunk. I'm trying to check on the okay. Okoth is saying, comment on background checks in light of the Data Protection Act. Now, background checks these days is becoming very difficult because the information that you get during that background checks, you cannot publish it anyway. As long as you're using it privately, and with the person from who you collect the information from. If you now publicize that information, that's where the problem comes with data protection. Because very many people now are becoming very skeptical with the new Data Protection Act. People's information is very, very, very private these days. So when you collect this information, make sure you're using it properly. Make sure you're using it properly. Okoth is also asking termination on probationary contract in light with the recent court's determination. Probationary contracts are also another very tricky one. There is one time we were in court over an issue like this. And you have to be able to do your how is it called? Your appraisal, right? You have to be able to do your appraisal properly. You have to be able to do your appraisal properly so that when you are now terminating on probation, on a probationary contract, you do not fall in the how do I call it? You do not go against the law. And there is one whereby somebody had been appraised, I think during their leave, and then their contract was terminated. They ended up in court, and the court said they cannot assess them when they are on leave, and therefore could not terminate their contract. Legality of only shortlisted candidates will be contacted. Yeah, that is valid. That is valid because how many applications will you receive and how many will you respond to? It is valid. It is valid legally. Lapse of fixed term contracts during leave, maternity leave, sick leave, paternity leave. If the contract has expired, the contract has expired. If the contract has expired, it has expired. Because you're going to pay this person their maternity dues, right? Isn't that the position? You're going to pay them. As long as you've paid them what is due, the contract has expired. If an employer wants to change or amend a contract before the contract period lapses, how should they go about it? They could just, they can do an addendum. And okay, you say an amended contract and both parties must sign. Both parties must agree to the contract and then sign it. Somebody is asking if there is any change on maternity leave if a child passes on. Yes, even if the child that is born dies, that female employee is still entitled to the 3 months maternity leave because they are still recovering from giving birth anyway. So they are still entitled to the maternity leave, and it does not convert to sick leave. It does not. Is it a requirement to have retirement age date on the payslip? No, it's not a requirement to have the retirement age on the payslip. It is not a requirement. According to legal notice number 28, it is not a requirement. For organizations with compassionate leave, does it include weekends or it's only taken on working days? It's for all leaves are calculated on working days, not on the weekend. All leaves are calculated on the working days. That is why they say maternity leave is 21 working days. 21 working days is so they always use the working days in calculation of the leave. Does the law provide for a specific number of warnings before an employee is dismissed? Is it still 3 years, 3? Does every company have their own policy? If there is no policy, then 3 is, it is. 3 it is. Why is 3 months maternity leave not applied in a private sector? For example, after delivery, an employee underwent cesarean section and they are required to report to work. No, that is wrong, Doris. That is very wrong. That organization is doing the wrong thing. It is doing the wrong thing. They are supposed to give leave in the private organization. 3 months maternity leave is a must. Whether the person gives birth normally or they, okay, I'm not saying 3 months, 21 days times 3. 21 days times 3 is a requirement. 3 months is a requirement. It is a requirement. Is it applicable across board unless the employee applied for maternity leave before delivery? Yeah, Christine, thank you so much for that. Yeah, maybe there are some people who take leave, by the way, before delivery. They say, oh, they have a complicated pregnancy, so they want to take leave. But 2 weeks is not allowed. Upon promotion, when is the salary review due? Is it after probation or immediately at promotion? It's supposed to be at promotion. Why after probation? Why after probation? It is supposed to be upon promotion, if that is the term of the contract, if it is in the contract. What is your view on the government directive on due diligence of academic certificates of all its employees? If found with fake certificate, what's appropriate action? Of course, the appropriate action is criminal proceedings. Appropriate action is criminal proceedings. And of course, if you attain the job by falsifying documents, should you have that job anyway? So criminal proceedings, I know they will be going for criminal proceedings. I know that. Phyllis is asking about sick leave. Is it still 7 days full pay, 7 days half pay? And there's no change on that. It's the same. It's the same. But some organizations have different policies on that. Must employers give a reason for not issuing an employee with a new contract, especially in the case where the employee has had several contracts before? Or no, it's not a must. It's not a must. But people don't like for their jobs to end, so it's not a must. Is a male employee entitled to paternity leave in a case where the child dies at birth? Yes. They are entitled. They are entitled to it because they need time to mourn and all that. They need time to mourn and all that. Okay, it's already 11:30. I'll answer this one more question. In a case where maternity leave overlaps with a fixed term contract. Yeah, we've already answered that. We've already answered that. As an HR manager, what is the take on a recruitment process in the recent KPA shortlisting of 12,552 candidates for availability of 150 slots available? Is it, of course, it's not practical, but it's their right. They have to choose from everybody and choose what they want. They choose from the best. Why does the summary dismissal part of the law give way to those placed in authority over others as concerning insulting language? Is it not discrimination? That one of use of abusive language. Now, yeah, they should. Nobody should use abusive language. Now, in that case, maybe if somebody uses abusive language and they are superior, maybe you can try criminal proceedings because the Employment Act does not really cover everybody when it comes to that. All right, we've come to the end of our workshop. It's already 11:33. Thank you so much for your patience and thank you for your time. For all the people that have attended up till now. I hope you've enjoyed and you've learned something from the presentation. The slides will be shared with you for all the people who have attended and paid for the course. The slides will be availed to you in the portal if you've paid for the course. If you've not paid for the course, you can still pay for it and then get the notes in the portal, in your portal. Thank you so much for your attention. I wish you a successful weekend and the rest of the year.